I got a surprise for Jack Smith. You got your wish. Trump is taking his case to the Supreme Court. He's asking for a stay on his appeal from that 3-panel fraud that came out. 2 of them were Biden appointees, and 1 was a very, very old George H.W. Bush appointment. Welcome to Doug in Exile. This is where all the happy patriots are. We're going to go through this article real quick, and you'll get all caught up on the first step Trump is taking with getting this January 6th case up to the Supreme Court. Now, remember, he's claiming that he has immunity, and he believes he has immunity to a point that he's willing to take it to the Supremes to find out. Here we go. Just in, Trump files legal brief will take presidential immunity challenge to the Supreme Court. Former President Donald Trump has filed a long-expected motion requesting a hold on an appeals court decision that rejected his claim that presidential immunity prohibits him from being prosecuted over his objections to the 2020 election results. How far are we going to take presidential immunity? That Judge Fan came up with a scenario going, are you saying that you could have SEAL Team 6 shoot an opponent? Which is ridiculous. That's not what he's talking about. He's only saying he should have immunity and be able to say that he disagreed with election results. Okay. Trump has asked the Supreme Court to pause the February 6th ruling from last week from a 3-panel judge panel of the U.S. Court of Appeals for the District of Columbia Circuit. That's D.C., so it's totally slammed lefty Democrat, rejecting his claim of immunity from prosecution. In a legal brief, the former president's lawyer warned that, quote, conducting a months-long criminal trial of President Trump at the height of an election season will radically disrupt President Trump's ability to campaign against President Biden ahead of 2024. So he's giving the Supreme Court another reason to not go after Trump and give him immunity. Ahead of the 2024 election, Trump's lawyers are asking the justices to halt the trial proceedings pending their request for the full slate of judges on the DC circuit to reconsider the case. When you get a full slate of judges in DC, instead of just those 3, it's called en banc. I don't know why that's what it's called, but it's a bigger deal to say, look, we think we need a full court on this and not just a panel of 3. If they don't choose that en banc full court at the appeals level, if necessary, the case will be appealed to the U.S. Supreme Court. There. That's the big game, and that's where this thing is headed. Because after that, Jack Smith has no say. He may have say over this 12-panel judge, but you go to the highest court in the land, and suddenly it's like, Jack Smith, everybody sit down and be quiet. We're going to weigh in on this. And that's what Trump really needs to get justice. The former president was initially slated for a March trial date on charges relating to special counsel Jack Smith's January 6th case. Though the case has already been removed from the docket, a new trial date has not been posted, nor is one expected until the appeals process has played out. So this goes into the whole timing thing of Chutkan pulling the case back, and now Trump really has a lot of room to run before the election. It's going to be hard to get this on the docket before he runs and we find out if he's president, and then he can dismiss all these charges anyways. The Supreme Court is already set to hear a case concerning the federal government's use of a novel legal theory to bring felony, quote, obstruction of an official proceeding, unquote, charges against hundreds of the January 6th defendants. This is the fishing expedition that they got the January 6th guys on. They went back to this obstruction of an official proceeding that happened during a 2007 or so Enron case, where they were afraid that a bunch of lawyers were messing with witnesses and testimonies, and they were getting them an obstruction of an official proceeding. That's what they're charging the J6th people with, saying that they obstructed an official proceeding of electing president or seating electors. Now, that is a stretch of the law so far beyond reality that it wouldn't hold at the Supreme Court. The legal theory also concerns half of Smith's 4-count indictment against the former president relating to the election challenges. So if they find that that Enron thing that they brought against both the J6 defendants and Trump as the guy who incited them all, half of his charges already go out against Smith. So the Fannie Willis case still sticks and the Judge Ageron case still sticks. But the J6 stuff, most of it, half of it goes away. Trump's lawyers have argued that allowing the case to proceed will have massive implications for presidential power, warning of additional politically motivated prosecutions and blackmail. Quote, without immunity from criminal prosecution, the presidency as we know it will cease to exist, his lawyers wrote. And this is a problem because you either give the president the ability to shoot an opponent with SEAL Team 6, or you have presidents after they get out of office hunted by the previous candidate for life, go after their family. And so the Democrats have acted like such a kangaroo court. They're going to force the Supreme Court to give the president immunity. Quote, any decision by the president on a politically controversial question would face the threat of indictment by the opposing party after a change in administrations. All presidential decisions would be exposed to undue wrongful pressure from opposing political forces under a threat of indictment after the president has left office, unquote, the brief continued. So I suspect the Supreme Court would side with the president, giving him limited immunity. That is, they wouldn't say this is case law. They wouldn't say he has absolute immunity or anything like that, but they'd give specific limitations. Quote, the threat of prosecution will become a political cudgel used to influence the most sensitive and important presidential decisions with the menace of personal vulnerability after leaving office, they added. In the February 6th ruling, the D.C. Appeals Court argued that, quote, the risk the former presidents will be unduly harassed by meritless federal criminal prosecutions appears slight, unquote. Well, it appears not slight because it's happening to Trump right now, and it's less slight when Democrats take office and can punish the previous guys, throw them in prison, put them on trial, bankrupt them, indict them on without a jury, trials without a jury. We need the Supreme Court to save this country, and I hope they do. We'll see if, first of all, if they give them the 12-panel jury, we'll keep it from going up to the Supreme Court, or they'll give them the 12-panel jury and then further appeal to the Supreme Court. Either way, Trump is not stopping until this thing goes to the Supreme Court. So ultimately, it's going to be up to them. They might as well take it, guys, and shut these Democrats down for the political apparatchiks they are. The day they take this case is the day Jack Smith loses. And even if they don't take the case and this thing is delayed until Trump gets elected, Jack Smith loses. Either way, we win, guys. Another victory for Trump. I'm Doug in exile.